Hello, and welcome to Let's Talk Immigration. I have to do this little thing on Twitter real fast so that my followers get to see this. Okay, good. Welcome to Let's Talk Immigration. My name is Curtis Morrison. I'm an immigration attorney based in San Diego County, California. Ready Go Law, it's my law firm. We are a remote law firm. We have attorneys and paralegals working all over the U.S., working hard on behalf of our clients. So we are working on the travel ban. That's the thing I want to talk about. If you didn't know, Trump didn't pass. He issued a presidential proclamation on June 4th that went into effect June 9th that is a travel ban that is a lot worse than like the Muslim ban he was known for in his first term, because this ban does not have a waiver. The State Department, I've learned today, has put up a website where they have information about the ban. But what's interesting is the State Department doesn't have everything that's in the proclamation. They have what they think is important. I think that's interesting. There must be a disagreement there. But there's still no waiver. There is one thing I want to talk about before I get to like our group challenges. I've been running into people that had issued visas that were revoked or canceled after the ban. That did not supposed to happen. It says right here on their website, foreign nationals, even those outside the U.S. who hold valid visas as of the effective date, are not subject to the proclamation. No visas issued before June 9th have been or will be revoked pursuant to the proclamation. That is a false statement, okay? I have a little Telegram group I've set up with the people in that situation, and we're talking about doing a little group lawsuit just for them in that unique situation. But bigger picture, though, challenging the travel ban. To my knowledge, the nonprofits that challenged it the first time, like the ACLU, ALA, all the other nonprofits that work in the immigration space, do not have the bandwidth right now to challenge this travel ban, because they are trying to prevent the largest mass deportation in history. And I'm excited that they're working on that, but they have limited bandwidth. So Ready Go Law is going to step into this space. It's a space we're familiar with because this is how I spent the Trump administration's first term, right? And some of our team actually worked on that issue as well during Trump's first term. So what we're going to do is we're going to take two, maybe three, but at least two of our existing lawsuits that have been filed in group lawsuits that have been filed in DC. Actually, neither one of those lawsuits were filed in DC. One was filed in California, one was filed in Missouri. They were both transferred to DC. One was for students, one was for employment-based, including a lot of EB2 NIWs, people that are geniuses, that were scientists and professors and top of their field, AI engineers. We're going to amend the complaints, if the judge lets us, in these two cases and challenge the legality of the travel ban through those cases. Use those lawsuits as vehicles to challenge the ban. The primary challenge will be under the non-delegation issue, that Congress did not have the authority to delegate this much authority to the executive under Section 212F. 212F itself is unconstitutional, is what we're going to say. And then the second thing is we're going to challenge the fact that 212F is an entry ban and not an issuance ban, so they should still issue the visas. But at the same time, understand that gives you limited relief, because if you have an issued visa, it doesn't help you if you're not going to be able to enter the U.S. It does help you from the respect that when the ban is rescinded or enjoined, you may have a visa and may be able to enter the U.S. then. And there's actually been an experience where that happened with DV 2020. Okay, let me see here. The other thing we're going to do is we're going to file 2 new group lawsuits. Okay, we're going to file one on behalf of diversity visa selectees who have already attended interviews, they went into administrative processing, or they've already been refused under 212F, using the same legal theories. We're going to make that lawsuit affordable. It's going to be $500 selectee. We're not going to charge extra for the derivative spouses or children. We had planned to launch onboarding of that lawsuit today or tomorrow, but now it's probably tomorrow or Friday. We've had a couple setbacks. So go back to our website by Friday, and we will have instructions on how to onboard if you are a DV selectee in administrative processing. The other group lawsuit will be, and this is only for people in travel ban countries, okay? The other group lawsuit will be for people in travel ban countries under the family preference categories, okay? A lot of Iranian families, a lot of Cuban families have been impacted of this because they have a lot of pending family preference category petitions or visa applications that can't go anywhere now. Okay. Present. The family preference categories, family sponsored preference, I guess, are F1, F2A, F2B, F3, and F4. So if you fall in one of those categories and you're from a travel ban country, we will be offering a group lawsuit for you to participate in and challenge the ban. We will not be begin onboarding that group lawsuit until we have onboarded the DV lawsuit. We're doing that one first. They have a deadline that they're facing in September. So I expect the onboarding for that group lawsuit will be in 1 or 2 weeks. Okay. So that's what we're up to. In the meantime, we still do individual mandamus lawsuits against USCIS or against State Department for people that are not impacted by the ban. For example, U.S. citizens petitioning for their parents or spouses. That's IR1 or IR5. Or if you're the visa applicant beneficiary in your case is not from a travel ban country. You know, there are 200 countries out there, and the travel ban is only affecting like 19 of them. So one more thing I want to talk about. One way to get out of the travel ban, if you're subject to it, is qualify for an exception. There's not waivers, but there are exceptions. And one of the exceptions is being a dual national and having a passport from another country. I've talked to some people about something called CBI, Citizenship by Investment. There's also CBD, Citizenship by Descent. And it is more affordable to obtain a second citizenship than you may think. If you're willing to never see the money again for $250,000, you can gain citizenship in Egypt. Although there's an option where you can spend $300,000, buy property, get the citizenship, and then sell the property later, after 5 years, I think. There are other countries, of course, that offer this. Turkey, Vanuatu. I don't know how to say it. Vanuatu. If you became a citizen of that country and you buy a house there on the beach, let me use it, though. That's the rule. It's South Pacific somewhere. So that's the lay of the land there. There are other countries that do citizenship by investment, but those are the ones I've been talking to people about. One more thing, national interest exceptions. There is some talk in the travel ban about how people can qualify for national interest. to my knowledge and the knowledge of my colleagues who work in this space, the State Department has not exercised that discretion with a single visa applicant. So, my advice is do not have hope that that is going to happen. When they deny a not deny, I'm sorry, when they refuse under 212F a visa application for a non immigrant visa, like a F1, F2, J1, J2, they say on the refusal notice and, um, well, on the refusal notice, they say, but you can present evidence for a national exception the next time you apply. I'm sorry, but that feels like a trap, like a scam. Like, why can't they look at national interest exception evidence now? Why do they have to refuse you and then take your money again for the opportunity to look at your evidence to see if you qualify for a national interest exception? So I would be hesitant to give the US government money for something just because of that language. Okay. I'm sure that there are going to be people out there that try it, and that's great. But if you're tight on money, I would not give them, I would not pay for a second interview, especially if your national interest grounds was shaky and not solid. You know, um, it's, I mean, I don't even think it's real. I don't think that they're going to issue visas under that national interest exception, but we will see. A lot of times litigation changes things and causes things to happen. So that's basically all that's going on with me right now. Um, one more thing. A lot of people are in a situation now where they need to file new petitions. They need to file an I-130 petition because the green card path it no longer works because of like a diversity visa derivative abroad, but the green card holders already, the selectees already in the U.S. You could set up a new path with an I-130. Same with K1 fiancés, U.S. citizens that had done a fiancé petition, but now the travel ban prevents that visa from being issued. Well, you can get married and do an I-130 petition. A lot of people are not excited when I tell them how long it's going to take, but it's a new path where right now you don't have one. So it's the way forward. Okay. I was going to say our law firm does represent people with I-130s. Get with me. You can go to our website, contact us, and book a consult there, free consults, if you want to talk about that. So, no questions today. I'm going to wrap up early, and then I'll see you next week for Let's Talk Immigration. Again, if you're interested in that DV group lawsuit, we will be onboarding it by Friday. Okay, hopefully tomorrow, but by Friday for sure. Thank you. Take care.